Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
You know, the fact that people were doing the legal stuff in an organized fashion does not kind of, by the transitive property, mean that the people who were doing the illegal part were in organized fashion. And by the way, if they weren't carrying guns, it doesn't count, really.
It's such a good point to remind, because, you know, I have been kind of marinating in the media coverage on this, and the rhetoric from the other side has uniformly been violent protests, violent protests, violent protests. And the fact that there's no evidence of people having guns is, a pretty good point to remind us of.
Welcome to Law and Chaos, where a trial judge in California has just ordered Trump to take his nasty orange paws off the California National Guard. Also, Kilmar Abrego Garcia is home, and Alina Habba is pretending to be a prosecutor again. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
Hi, Liz. I'm great. I mean, today whipsawed us around quite a bit, right?
Yeah.
It ended with Judge Breyer in California issuing injunctive relief with respect to Trump's efforts to federalize the National Guard and try and stoke violence in Los Angeles. So that was very good.
Yeah, it's a great order.
Yeah, but that came a few hours after Kristi Noem had a sitting U.S. senator tackled to the ground and handcuffed for criminal, being a Democrat. Liz, do you want to do the dishonors here?
I absolutely do. So that was the Department of Homeland Security Secretary Kristi Noem claiming that she was going to liberate California, specifically Los Angeles, from its socialist leaders. And before we get to any of the other stuff, I want to just take a minute to think about how incredibly anti-American and undemocratic it is that a cabinet secretary says that she is going to bring in troops to fight against the elected leaders from a city and state. I mean, that is as scandalous, I guess, as anything else which happened. But obviously what happened at the end of this video is that California Senator Alex Padilla was arrested, he wasn't charged, but he was tackled and, as you said, handcuffed by FBI and I guess Homeland Security agents for daring to ask a question at a public press conference in his own state.
Yeah. Noem advanced this weird argument that said, well, he didn't identify himself, so we didn't know who he was.
Like, he was just some rando.
A sitting senator on the Senate Judiciary Committee.
Yeah, of all the things that are horseshit, that is horseshit the most. Like, first of all, Kristi Noem has testified to Congress a bunch, including before committees, including, I think, the Judiciary Committee and committees on immigration. So she's testified before Padilla.
She's been questioned by Padilla. Yeah,
100%. She knows who the hell he is, and so does everybody else. So for them to say, well, he didn't announce himself, like, first of all, it's a lie. He said, I am Senator Alex Padilla. And second of all, it doesn't matter. It doesn't matter. We don't tackle people to the ground.
Yeah.
Go ahead.
I also don't want to lose sight of the comment that you made before that, which is just how chilling, we're going to liberate Los Angeles from its socialist leaders is, right? Like, and as always, you can play the make it Biden game, right? Like, if Joe Biden had said, I'm sending in the National Guard to liberate the state of Kentucky from its, right-wing Cro-Magnon leader, right? Like that, you cannot imagine that. That is not a possibility on the other side, but, it is the reality we live in.
Yeah, and look, while we're still talking about Noem, it is not illegal to dox ICE agents, right? You may think it's a shitty thing to do. I personally don't.
No.
But you may think it's shitty, but it is not illegal. And for her to say we're going to crack down on people who dox ICE agents, I mean, they might try, but it is absolutely not illegal. That is core First Amendment protected activity.
They arrested the guy handing out face shields in Los Angeles to try and protect demonstrators from pepper spray. So
Right. I mean, they're doing a bunch of crazy shit. I did look for that indictment earlier today. I assume it's a criminal complaint and not an actual indictment, but they said that they charged him with like conspiracy to, I don't know, impede officers or some crazy shit. I will find that.
yeah, it was an 18 USC 371 charge, right? The same charge brought against the actual January 6th insurrectionists who are now, all heroes who deserve reparation. But I'm going to go before my blood pressure spikes above 9,000.
Yeah, well, on that topic, here's House Speaker Mike Johnson explaining that the person who is at fault here is Senator Padilla.
I think that we should act according to our offices. We have a duty and a responsibility to set a tone, an example in our actions. And I encourage every member of this body to do it in the House and Senate. We have to turn the temperature down. We need to be on the side of the rule of law. We need to be on the side of law and order. We need to be on the side of calm and not chaos. And when members go into these settings and act this way, that when they push law enforcement agents around, when they storm cabinet secretaries in a press conference, I think it is wildly inappropriate behavior, and I think it sets a terrible message and tone for the rest of the country.
Will there be
an
investigation? Will there be a House investigation?
This is a Senate side issue, but I certainly hope that behavior is not repeated over here. We already.
Constitutional officer for this branch of
I am,
government. This
yes.
affects all members, whether they be in the House or Senate. You're the Speaker of the House.
Yes.
The constitutional officer of this branch.
Yeah, and what of it? I mean,
The idea that you said this is a Senate issue. This isn't. I mean, these are members of Congress.
Yeah, but the Senate does its disciplinary actions over there, and we do ours over here. We have a certain set of measures, as you all know, and it ranges from censure to removal from committees to ultimately expulsion from the body.
And do you support that for the senator?
It's not my decision to make. I'm not in that chamber, but I do think that it merits immediate attention by their colleagues over there, and that they need. I think that behavior at a minimum is. It rises to the level of a censure. I think there needs to be a message sent by the body as a whole that is not what we are going to do. That's not how we're going to act. We're not going to have branches fighting physically and having senators charging cabinet secretaries. We got to do better, and I hope that we will.
Oh, he was the founder of the House Civility Caucus. Good to know on that. Yeah, I really think when I survey the landscape, when I survey federal agents shooting journalists in the back with, less lethal munitions, I really think the problem is that Democrats are not being polite enough. Give me a fucking break.
Yeah, I mean, look, that's not going anywhere. I do not think that the Senate is going to censure Alex Padilla. That's ridiculous. And, he's Speaker of the House. He can say whatever stupid shit he wants. And God knows he will.
Yeah, but I mean, it does define the discourse downward,
Absolutely.
But Liz, right, we've had our outrage. I want to ask you what your thought is about how to respond here, right? Like, part of me wants to say that the state of California should immediately swear out arrest warrants for those officers, right? Like, that is battery. Those officers know better than to tackle a senator and handcuff him. But then part of me thinks that escalating the violence against the Trump administration is not going to end well for our side. I don't know. What do you?
Yeah, think? I think that that's functionally a non-starter, right? Nobody in the government is talking about that, and I think that they've got bigger fish to fry. Look, we're going to talk about the big order that came down in Judge Breyer's courtroom today. So I definitely think that Newsom is going to not deal with any picayune shit about that.
Yeah, I think you're right, but I guess I'm just trying to think about, the position that I took unwaveringly in the first Trump administration. I think you did too. Was protest, go out, speak your mind, but I want our side to condemn the violence. And now, when the other side is beating up and arresting elected representatives for the temerity of being Democrats, I don't know what the right answer is.
Yeah, I would say it's not that, but I know that many on our side would differ. Okay, we're going to take a quick ad break unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case you are not going to have an ad today or ever at any time. And we're back. Okay, so remember when the U.S. Attorney for New Jersey, Alina Habba, filed a criminal complaint against Newark Mayor Ras Baraka?
Who could forget? Oh, also, glad that it falls to me. I think we are legally obligated to say Alina Habba, Donald Trump's personal lawyer, who was so successful that she netted him negative $500 million in judgments between the civil fraud trial, the 2 E. Jean Carroll lawsuits, and that preposterous RICO troll suit that she filed on his behalf in Florida. That was against Hillary Clinton and like a whole stringboard of Democrats. That one was so crazy that Judge Middlebrooks sanctioned Habba and Trump collectively to the tune of $1 million.
Oh, it wasn't just Hillary Clinton and Democrats. It was James Comey and Rod Rosenstein as well.
Rod, that one hurts. I mean, gone, but never in our hearts.
Not anymore. So the Baraka indictment arose out of a series of events on May 9th at Delaney Hall, which is an ICE facility which just opened up in Newark, New Jersey. It is run by the Geo Group, a private prison company, which was just awarded a 15-year, $1 billion contract to run this 1,000-bed facility. Now, Newark, New Jersey did not want this facility there.
No.
There's been massive protests. City officials say that they've been blocked from inspecting the facility for health and safety issues. Okay, so we've talked about this several times on the show, but just to remind ourselves, there was a protest outside the facility on May 9th at which 3 New Jersey United States Congresspeople, that is Rob Menendez Jr., Bonnie Watson Coleman, and LaMonica McIver, were there, as was Mayor Baraka. Now, the 3 Congresspeople were allowed into the facility. There were some, well, the government has had several competing narratives about this. They put out tweets suggesting that the Congresspeople snuck in behind a truck of detainees, like the gate was open and they darted through it. Legal documents this week said that the Congresspeople were let in and then Baraka was, quote, allowed to enter into the secured area when the guard became concerned for his safety amidst the crowd of protesters. But the guard later told Baraka that he could not enter without authorization and ordered him to leave the secured area. And I mean, we've used a lot of swears already on this word, but that is also bullshit, right? Like, I'm sorry. Baraka's out there with his security detail and all of the protesters who are on his side. And then the guard, out of the goodness of his heart, says, "Sir, Mr. Mayor, come inside this facility," and then leave the facility. Like, I don't know what happened, but I know that's not what happened.
Well, that's better than the first version that Homeland Security put out, which was that those members of Congress, including, I want to point out, Bonnie Watson Coleman is 80, right? That they stormed the gate, broke into the detention facility, were holed up in a guard shack, right? Like, a la, Last Stand at the OK Corral or something. That was the first security checkpoint. Like, none of that happened. Okay.
Yeah.
In fact, members of Congress are allowed by law, by a provision inserted by Republicans in Congress into the Consolidated Appropriations Act of 2024 that allows members of Congress to inspect ICE facilities without having to announce their presence first. They don't have to call. They don't have to get permission. They can just show up. But in fairness, right, that does not extend to mayors, so it did not include Baraka.
Right. So however Baraka got inside the gate, he was inside the gate for a few minutes. Right. Sure. He probably scaled it like Spider-Man. He was then threatened with arrest if he wouldn't leave. And he did indeed leave, after which ICE agents came out and tried to arrest him. And a bunch of people, including the mayor's security detail and the crowd, tried to form a human chain around him. Now, that included Representatives Coleman and McIver, and there was like a scrum. We've all seen the video of it. There was this scrum, and I think it is fair to say that somebody tried to get, one of the ICE agents or the HSI agents tried to get his arm under or inside the scrum to grab the mayor, and LaMonica McIver maybe sort of gave him the back of her hand, not like a slap, but just to kind of swat him off of her body. Right.
I guess, but we are talking about an ICE agent or HSI agent in body armor and somebody who's a member of Congress, right? Right. This is not a threat.
Right. And the way that the Homeland Security spokesperson, Tricia McLaughlin, says, we have body camera footage of those members of Congress assaulting the ICE enforcement officers, including body slamming a female ICE officer. And that one maybe is even less likely than them being holed up in the guard shack. I don't know whether, as you said, Bonnie Watsy Coleman is 80. LaMonica McIver is, in her 30s, but not the largest or the fittest woman I've ever seen. And Rob Menendez wasn't even in the scrum. He just looked really confused in all of the footage. Probably because his dad is Bob Menendez and he's got a lot on his mind. Yeah. Leave that to the side. The point is, there was no body slam. There was no hold up in a guard shack. And LaMonica McIver was mostly jostling and being jostled. Okay. So after this, they file a criminal complaint against Ras Baraka for misdemeanor trespass, which Habba dropped 2 weeks later, which she claimed was for the sake of moving forward.
Oh, healing the nation. I'm
that's how real prosecutors talk. Okay. Yeah. So Magistrate Judge Andre Espinoza reams the U.S. attorney who has to come in, the assistant U.S. attorney who has to come in and say, we're dropping this case. He calls this an embarrassing retraction. The magistrate says, your office must operate with a higher standard than that, and your job is not to secure convictions at all cost, nor to satisfy public clamor, nor to advance political agendas, which I don't know whether he's met the U.S. attorney, the interim U.S. attorney for the state of New Jersey, but no, Ann, that's really her job. That's advancing political agendas.
Yeah, right. I mean, that is the only thing she's competent to do. And I will point out that we made the joke when she was in private practice about, who would be Alina Habba's underling. But now, real, actual career prosecutors, civil servants in the U.S. Attorney's Office in the District of New Jersey have to report to this person. The mind boggles. Anyway, Mayor Baraka sued Alina Habba civilly. We will talk about that lawsuit as it moves forward. Not a lot to report right now. Meanwhile, Habba initially filed yet another criminal complaint against Representative McIver at the same time that she was dropping her complaint against Mayor Baraka. And we've mentioned this before, but a criminal complaint is a lesser standard than a criminal indictment, right? That is just the prosecutor announcing these are the charges that we believe we will be bringing. You have 30 days from the issuance of a complaint to actually go to a grand jury and get an indictment, because you have a Fifth Amendment right to be indicted by a grand jury. And the way in which these are supposed to be utilized is when you have an exigent circumstance, right? You've got somebody who is about to flee the jurisdiction or flee the country or is an imminent danger to this, right? And so you've got to get something out right now and you just don't have time to impanel a grand jury. That's how prosecutors, left, right, center, have utilized criminal complaints since time immemorial. Also, if you have a cooperating witness, I suppose I should say for the sake of completeness, right? If you've got somebody who's already plea bargained down, you can issue a complaint. That way you don't have to go impanel a grand jury for somebody you're not going to charge anyway. But those are the circumstances in which you issue criminal complaints, not against your political opponents.
Right. But that's not what happened here, because see above, all that she's competent to do is advance political agendas. So Habba actually did indict sitting Representative LaMonica McIver on Wednesday for assaulting and impeding an officer in his official duties. So there were 2 felonies and 1 misdemeanor for body slam.
We've referenced the joke on this show and elsewhere that, the standard for getting a federal indictment is so low, the scales are so tilted towards the prosecution that a grand jury will indict a ham sandwich, right? And the reason is because a grand jury is a one-sided presentation, right? The target of that grand jury, here Representative McIver, not entitled to be present. They're not entitled to introduce evidence. That their lawyer isn't there. They can't cross-examine the witnesses. It is just the government laying out its evidence. And the grand jury standard, they only have to find that there is probable cause to believe that the crime occurred, right? Not that it's even more likely than not, and certainly not, proof beyond a reasonable doubt at that stage. A grand jury need not be unanimous, right? Like you can secure an indictment. You impanel up to 23 members of the grand jury. Sometimes they swap in and out because grand jurors are, sick or what have you. And so long as you get the votes of a bare majority of 12 out of that 16 to 23 members on the grand jury, you have an indictment.
Which is exactly what they appear to have done. They have gone and gotten an indictment against LaMonica McIver. Now, that's not the same as saying that they're going to be able to bring this case to trial, particularly because LaMonica McIver is the congresswoman who represents Newark.
Right.
So they're going to have to get her own constituents to convict her unanimously and, proof beyond a reasonable doubt. So, good luck on that. Good luck on convincing people. I mean, not for nothing. Marjorie Taylor Greene does a lot of CrossFit, and she does look like she could, throw down. And I'm not, LaMonica McIver looks like a normal lady who doesn't do CrossFit because she actually does her job. So,
but look, there's a serious point here that I want to kind of tease out that you're alluding to, and that is that the standard that must be proven here as a predicate for bringing any of these charges is assault, right? That is that Representative McIver made this ICE agent in body armor in fear for his safety, and that she intended to do so. And I agree with you, right? You're not going to find a single juror on the basis of this evidence that's going to believe that. That's.
I mean, you might find a single one, but I don't think you're going to find 12 of them.
a fair point. But even if you could, Representative McIver has the defense of the speech or debate clause, right? Which protects members of Congress from prosecution in connection with carrying out their official duties. And the case law is really, really strong. That in connection is broad. And she was clearly involved with her duties there, right? She's investigating an ICE facility. That is core congressional business. So yeah, this is just nonsense.
Yeah. So, okay. As we said, the case against Ras Baraka kind of disappeared. We'll see what happens with this case with Habba. That was really embarrassing for her to disappear that Baraka case, and there's probably a fair amount of pressure on her not to do the same. If she does actually go to trial with this stinker, the case will be heard by Judge Jamel Semper, who was a U.S. attorney in Habba's office. He's actually an experienced prosecutor. He was appointed to the federal bench by President Biden. That case is set for arraignment on Monday the 16th at 11 a.m. The congresswoman will appear remotely because, see above, she actually does her freaking job. McIver called this a brazen attempt at political intimidation. She said the facts are on. Yeah, no shit. She said the facts are on our side. I will be entering a plea of not guilty. I'm grateful for the support of my community, and I look forward to my day in court. Oh, I bet she does.
I bet she does.
Okay, we're going to take another brief ad break unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com. Hang tight, guys. See you in a second. And we're back. A lot of updates today on Kilmar Abrego Garcia, who is now thankfully at least back in the United States and under the jurisdiction of U.S. courts, and not someone who calls himself the world's coolest dictator. That would be Nayib Bukele, the president of El Salvador. So first, the Trump administration has now conclusively demonstrated what we already knew, which is that, of course, it has the power to bring back anyone it has renditioned to El Salvador and theoretically handed over to Bukele. That has implications for a bunch of other cases, including one called JOP v. Department of Homeland Security. We've talked about that on a bunch on the show. That's the one in which the administration violated a consent decree that it had promised not to deport anyone who arrived in this country as an unaccompanied minor until their petition for asylum was adjudicated on the merits. And yet it deported this fellow Christian who had a pending asylum claim to CICAT in El Salvador.
But don't worry, because the administration dummied up an indicative ruling that said, if we had given him an asylum hearing, he totally would have lost. So, what's the big deal?
I know, don't really think that's how it goes.
No, it isn't.
And neither did Judge Gallagher, actually. So the settlement was adjudicated in Maryland in front of Judge Gallagher, as we said. And 6 weeks ago, in language which mirrored Abrego Garcia, Judge Gallagher ordered the government to facilitate Christian's return to the United States. And that's one of the things that we're seeing as the lower courts and the circuit courts kind of feel out the lengths of what the Supreme Court is willing to force the Trump administration to do, if anything. They are modulating their orders and kind of referencing each other. And we're going to talk about that later with respect to Judge Breyer.
Yeah, I think that's right. And so in that case, the DOJ has been, filing these completely non-responsive bullshit status reports saying, yeah, we're absolutely facilitating Christian's return to the United States. This is the case in which they got Melissa Harper, who is the acting deputy associate director of removal operations at ICE, to say in her declaration that Secretary of State Marco Rubio totally pinky swore to her that he was definitely taking care of things. It was all handled. Everything's fine. She actually filed another declaration on Friday, June 6th, at literally the same time that Abrego Garcia was being returned to the United States. And that declaration said, I told you Marco Rubio's got this under control. Quote, the nature of the diplomatic discussions necessitated by this court's order required engagement with the highest levels of the Salvadoran government, which I like, it's just proven you're full of shit while you're filing this. So at the same time, the proof that was not true was on a plane being returned to the United States. So, the government's just that they were lying then, they're lying now.
And so, not unexpectedly, Christian's lawyers filed a notice on Monday morning with the court advising Judge Gallagher that the government had indeed produced Abrego Garcia, despite having previously told Judge Exinis that they do not have the power to produce him. And also that they, the plaintiffs in the JOP case involving that fellow Christian, served expedited discovery requests on the Department of Justice for their failure to comply with the court's orders. Because, and just to make this pellucidly clear, once the government has conceded that it can get people out of CCOT, it's conceded that it can get people out of CCOT. And thus, Christian can be got out, and so can all of the other people who have filed these habeas petitions, which are now pending before Judge James Boasberg.
Yep. So we will see how that affects those pending cases. We'll obviously continue to monitor. Okay, second development with respect to Abrego Garcia is that in the federal criminal case that the government dummied up against him, the government has also moved to hold him without bail.
Yeah, can I break in here? Because we discussed how the charges were likely bogus in our last episode, but I want to emphasize the timing of how all this came down. Because as Abrego Garcia's lawyers have told the court, it looks awfully suspicious, right? Attorney General Pam Bondi, who is always willing to violate the Justice Department manual's ban on talking about pending cases in ways that might prejudice the jury. She refused to answer questions about when the criminal investigation into Abrego Garcia began. And the grand jury returned this indictment on May 21st. So you don't have to be Inspector Clouseau to figure out that they impaneled that grand jury and started the case even before that, even at the same time that they were saying, there's just no possibility that we can get this guy back, right? They began investigating Abrego Garcia in April at the very latest, which is years after he supposedly engaged in this human trafficking, which they're now accusing him of it. And so, look, April is when Judge Exinis ordered expedited discovery into the government's defiance of her orders. So, I mean, not to put too fine a point on it in case I'm being too subtle, they very clearly back-formulated this criminal case in anticipation of bringing him back, even as they were saying we can't bring this guy back, so that they could bring him back and then deport him again and say, obviously we did the right thing to deport him. And also this case before Judge Exinis where we might well get held in contempt, that should go away.
That last one I think is maybe even, the horse leading the cart, or however that analogy goes, right? I think it's pretty clear that once the administration realized it was in potential danger of contempt, it wanted to make this case go away the same way that the Supreme Court wanted to make the JGG case in front of James Boasberg go away, right? And indeed, they have moved multiple times throughout this litigation including after Abrego Garcia was returned to the United States and then indicted in the Middle District of Tennessee, to dismiss that case as moot.
I don't think that Judge Xenius is going to go for that shit. Like, there has not been an order as of now. There's just been a lot of like back and forth on the docket between the two sides. You know, the government saying, and now we're done here. Bye. Hey, thanks. Bye. And the lawyers for Abrego Garcia saying, no, we're not.
Yeah, not so fast. Well, we're going to talk about that in a minute. But I do want to talk a little bit about the fact that because this administration has, cruelty as one of its guidepost principles, right? Like it has now moved in that trumped up criminal case to detain Abrego Garcia without bail. Except, of course, that the Department of Justice failed to brief the actual legal standards that it needs to do so in order to have such a hearing. So let's do that for them, right? Like, and I want to start off with the fundamental principle that it is disfavored to take away someone's liberty before you have given them due process, a trial, and put the government to its burden to show that that person has broken the law.
I mean, it used to be disfavored. It kind of seems to be pretty highly favored at the moment.
Yeah, I mean, I yearn for the days of, let's say, Chief Justice William Rehnquist, not exactly a liberal squish, one of the frequent targets of my ire for most of my career. Here's how he put it in a 1987 case called U.S. versus Salerno. He said, liberty is the norm in our society. Detention prior to trial or without a trial is the carefully limited exception. And that exception is codified by statute as the Bail Reform Act of 1984. Is 18 U.S.C. section 3141 et sec. It says basically that the government must prove two things, right? First, they have to prove that a particular criminal defendant is either charged with an extreme crime, and that's defined in the statute. We'll talk about that in a minute, or that he is a flight risk, right? So that's kind of prong one. And prong two is that no other condition or combination of conditions will reasonably assure the defendant's appearance at trial. So regardless of what you see on TV, right? The government's got to prove both of those conditions.
Right. And it has to prove both just to get a bond hearing.
Right.
And at the hearing, the government can then argue that the equities favor pretrial detention. But unless the government can prove that you're charged with a crime which fits into the narrow statutory grounds we'll talk about in a second, it doesn't even get that hearing. It can't even make the argument that the society would be better off with you behind bars pending your trial. And as it turns out, the government's motion for pretrial detention for Abrego Garcia did not even mention those statutory requirements.
Well, counterpoint, at least it had a table of authorities and a table of contents, which, because a joke is always funnier when you explain it, in the Newsom versus Trump case that we're going to talk about in the next segment, the government filed its opposition with just a blank table of contents and an insert in brackets on the table of authorities, which is like a level of incompetence I have never seen before in lawyering. Like,
counterpoint, there's like 8 people left at every U.S. attorney's office, and they're a little overworked and also not the best.
and it takes all of their effort being evil full time.
Yeah. So anyway, when Abrego Garcia's lawyers pointed out to the court that the government was not entitled to a hearing, the Justice Department once again backfilled with a, quote, supplemental memorandum saying that it was entitled to a detention hearing in this case for 3 reasons. First, it said that Abrego Garcia's charges involve a victim who is a minor.
Yeah. The most charitable thing I could say about that is that it is a complete and total misinterpretation of the statute, right? Like, Abrego Garcia is charged with human trafficking, and we're going to explain that is not a crime for which the victim is a minor is one of the elements. But more likely, this is just an out lie, right? Like, because the provision of the Bail Reform Act that uses the words involve a victim as one of the statutory crimes that makes you eligible for pretrial detention, that section, it involves a victim who is a minor, is meant to cover crimes like child sexual abuse materials, right? Where you might not have the actual victim as a witness for an awful lot of reasons, right? Like, but here, Abrego Garcia is not charged with trafficking minors. He's charged with trafficking adults. But the government says because paragraph 23 of the indictment alleges as a factual matter that the larger conspiracy transported, quote, children on the floorboards of vehicles to maximize profits, end of quote. That half a sentence, that's it. They say that means the crime now involves minors. And that is just, that's not the law. No case says that. No case has ever said that.
Right. Well, so the second asserted basis for his detention is that Abrego Garcia is a flight risk.
We've laughed a little bit because we have to avoid crying. I cannot tell you how angry this section of the brief made me, right? Like, this government illegally renditioned Abrego Garcia to a foreign gulag in violation of a court order. It lied for months about getting him back while it was manufacturing criminal charges. And now they say he's the one who's the flight risk. And they say that knowing that the second Abrego Garcia is released from criminal custody, he will be taken back into ICE custody. Like, there was nobody who was less of a flight risk in the United States than Kilmar Abrego Garcia.
Right. Who apparently doesn't have any money anyway. How's he going to go? It's not like he has a private jet or something. But interesting. I mean, you're talking about the government saying, well, he has to be detained because even if he's not detained, we're going to take him into ICE custody anyway. It's like, how could he possibly be a flight risk, A? And B, his own lawyers are saying, if indeed he is taken into ICE custody, we're going to file a habeas petition because there's no reason for that. And, you know, the government has already demonstrated such bad faith here.
Yeah.
But, okay, so the government asserts that he's a flight risk because he's facing a, quote, potentially lengthy sentence. And people who face long sentences have an enormous reason to flee. And he's supposedly been used to living in the shadows.
Yeah, the shadows of suburban Maryland.
Right, he was picked up in
those
Hyattsville.
well.
Come on, he was a union guy. He was not living in the shadows. It's like such offensive bullshit. But they say that he was in this illicit world of an international smuggling ring that requires repeated contacts with individuals used to operating outside the law. What they did was they picked this guy up driving contractors from job site to job site. Right?
Yeah.
That's what it was. Were they undocumented laborers? I guess. Probably. I don't know. I wasn't there. You weren't there. None of these guys were there. And they only, as we said on Tuesday's show, I think it was on Tuesday, they claim that he was on 100 runs, and they know this because they picked his license plate up on one run. Yeah, if he was driving people, they'd have evidence of it. This is just insane bullshit.
Yeah, but I want to point out, even if all of that were true, none of that is the law. Right? Like, to say someone's a flight risk because they face a potentially lengthy sentence is to read out flight risk from the statute, right? Like, because you already have to show that they're facing a potentially lengthy sentence, right? Like, it's just nonsense. The actual legal standard, right? To show that someone is a flight risk, the government must demonstrate that the defendant has things like, a history of evading arrest, a systematic history of international travel.
On purpose, not because he was renditioned.
Yeah, strong connections to another country or countries that would lead him to flee there, right? Or at minimum, the thing that you have in every single case is a prior felony conviction, and none of those things apply to Kilmar Abrego Garcia, right? He fled from El Salvador as a teenager to escape targeted gang violence. It's not like he's got, high-level operatives back in that country. He's never been convicted of a felony. He has no history of arrest. And as you point out, Liz, he has never voluntarily traveled internationally.
Right. So finally, the government argues that Abrego Garcia is a, quote, serious risk to intimidate witnesses and / or obstruct justice because he's a member of MS-13. And that's just how gangs roll. Which is preposterous. We know that the government's MS-13 argument rests on the fact that he has a Chicago Bulls hoodie, which is what he was wearing. So, that's nonsense. But even if he was in a gang, that is not enough to meet this standard. You have to show directly to get somebody detained pending trial that he poses a risk, either personally or through intermediaries, of intimidating or killing witnesses, and they just don't have any evidence of that. So We'll see what happens here. Presumably, Abrego Garcia will not be detained without bail, but I mean, I don't know.
Yeah, neither do I. We will be watching. Okay, last update here. We want to talk about Abrego Garcia's initial habeas case in Maryland before Judge Xeni's that we've alluded to throughout the segment. That's the one that kicked all of this off. Unsurprisingly, Liz, as you alluded to earlier, the Department of Justice claims that case is all moot now that they've brought him home. And Abrego Garcia's lawyers claim not that. And one of the reasons it's not moot, in their view, is that they are entitled to sanctions for the government's conduct throughout. And on Thursday, Abrego Garcia's lawyers filed that motion for sanctions. That motion documents at length all of the ways that the government basically threw up two big middle fingers to them, to the court. Despite Judge Xeni's holding multiple hearings and issuing multiple orders requiring the administration to comply with, basic procedure and discovery.
Yeah, so to that end, something that's got a lot of attention is document 195-4. That's Exhibit D. We will link to it in the show notes, which is a, quote, non-exhaustive list of nearly 100 public statements administration officials have made about this case, nearly all of which are outright defiant of Judge Xeni's orders. Like on April 16th, when Pam Bondi stated unequivocally that Abrego Garcia is not coming back to our country. There is no situation ever where he's going to stay in this country. None. Or Marco Rubio saying under oath during a Senate hearing that no judge can tell me how I have to outreach to a foreign partner or what to say to them. And if I do reach out to a foreign partner and talk to them, I have no obligation to share that with the judiciary branch. What I won't comply with is an order to disclose what I'm saying. And if you're a subscriber at lawandchaospod.com or on Patreon at patreon.com/lawandchaospod, we're going to walk through everything that sanction motion says. Join us for all that nothing the government did to comply with the court's orders. And if not, we're going to see you on the other side of this brief ad break to talk about Gavin Newsom's lawsuit, successful this evening against Trump's invasion of Los Angeles. We will be right back.
And we're back. Liz, I have a feeling that we're going to be talking about Trump's invasion of Los Angeles for a while. Just to set the stage, as you know, on Saturday, June 7th, President Trump issued an executive proclamation invoking 10 U.S.C. Section 12406, which gives the president the emergency power to federalize a state's National Guard to suppress an insurrection, a rebellion within that state. You do not need us to tell you there is not a rebellion in the state of California.
Right. So on Monday, California Governor Gavin Newsom sued the Trump administration, seeking a declaration from a federal judge that the proclamation federalizing the California National Guard and sending them into the streets of California was illegal. We talked about that a bunch on the Tuesday show. The lawsuit landed on the docket of Judge Charles Breyer, who is the 83-year-old kid brother of former Supreme Court Justice Stephen Breyer. And on Tuesday, Governor Newsom moved for a temporary restraining order to prevent what the state said was imminent risk of the administration violating the Posse Comitatus Act, which prevents the president from using the military to enforce civil law.
Yeah. California filed that as an ex parte, a one-sided request. They asked for the TRO to be entered immediately. The Department of Justice turned around and requested 24 hours to file an opposition, which Judge Breyer granted, right? So the government filed its brief on Wednesday. California filed its reply brief on Thursday morning. Judge Breyer held a hearing on the merits on that TRO on Thursday afternoon. You and I, Liz, wrote about the government's opposition brief on our Substack at lawandchaospod.com.
Yes, indeed, we did.
And then after that hearing, which we attended, we're going to talk about, at about 9 p.m. Eastern time, Judge Breyer issued the TR.
Yeah, it's a terrific order.
Yeah, you want to kind of talk about it in broad outline, Liz?
Right. So what we're talking about here is a proclamation by the president in which he summoned the National Guard. And the basis for this was 10 U.S.C. Section 12406. And that statute has three circumstances in which the president can substitute himself as commander of the state militia. The first circumstance is if the United States is invaded or is in danger of invasion by a foreign nation. We're clearly not that. The second circumstance is when there's rebellion or danger of rebellion against the the authority of the government of the United States. Okay, I don't think that there's rebellion, but that was one of the ones that they argued. And the third is that the president is unable with regular forces to execute the laws of the United States. Trump, in his declaration, said that resistance to the laws of the United States, resistance to ICE raids, amounted to a rebellion, which is functionally defining rebellion down to, if you break the law, that's rebellion. And that can't be the definition of rebellion. And so the Trump administration sort of had to kind of backfill by massively overstating what went on in California over the weekend and on Monday and Tuesday, right? Which is that there were large-scale protests and there were small pockets of violence. The Trump administration was highly invested, and the media went along and certainly helped in portraying those small pockets of violence as if there'd been a whole breakdown of society in Los Angeles. And weirdly enough, there was all of this AI slop, right? There's all of these AI-generated images that made it look as if the city was on fire. And that's just not what happened. And I mean, with all love for California and Los Angeles, they do know how to throw a riot when they wanna. And this wasn't it. No, obviously it wasn't it. And so the government had to kind of tell these lies in its pleading where they're like, well, kids were throwing rocks at us and thus that's a rebellion. And that's just, no, it isn't. So that's not a great argument to be making when you're going in to speak to a federal judge.
No, and so the legal argument that they came prepared with for Judge Breyer maybe went over even worse, right? So the Trump administration sent in Brett Shumate, who is acting. He is the nominee to be the Assistant Attorney General to head the civil division at the Department of Justice to argue this case. And his argument was that the president's power here is plenary, that this is a non-justiciable determination. And here's what that means, right? That means a rebellion is whatever the president says it is. Mm-hmm. And I thought that Judge Breyer really dismantled that cleverly in kind of two ways, right? So first, what he did was pepper Shumate with questions about the factual determinations, right? He was like, so what did you do to show that there was a rebellion? And he said, yeah, we briefed out that, they were throwing rocks and mangoes and they lit a car on fire and this and that. And then Judge Breyer kind of sprung the trap and was like, well, why'd you do any of that if the power here is non-reviewable, right? Can I even look at any of your evidence if it's non-reviewable, right? And then after Shumate kind of hemmed and hawed at that for a little bit, then Judge Breyer sprung what I thought was really the killer argument, which was a reductio ad absurdum. He said, fine, let's assume that this is non-justiciable. Let's take something that we know is non-justiciable, that courts can't look behind. And that is the president's executive power to fill vacancies in the executive branch, right? Nobody can second guess who he puts in those spots, right? That's why Trump has inserted so many horrible human beings that could have never survived Senate confirmation into vacancies, right? And then Judge Breyer asked, suppose the president says that a job is vacant and it isn't. Isn't it the job of the courts to determine that factual predicate, right? Even in non-justiciable areas, don't we at least have to determine, or do I have to take the president's word that a job is vacant when it's not? And Shumate had no answer to that. And it really dovetailed with, and this was the case that was cited in Judge Breyer's order. It's a 1962 decision called Baker versus Carr. It set forth the political question doctrine and basically pointed out that the standard for something to be a non-justiciable political question is that it must be unmanageable from a judicial standpoint, right? There must be no standards that a judge can apply to determine whether something is true or not. And here, right, there are lots of standards to determine whether there's a rebellion or not.
Right. And so having decided that this was not a non-justiciable political question. He says, okay, what is rebellion? And he comes up with a bunch of different definitions, specific legal definitions and dictionary definitions, because that's a fun game that the Supreme Court likes to play these days. And he's like, fine, we all know where this is going. Let's just, get it in gear. So he says rebellion is open, organized, and armed resistance to an established government or ruler, especially an organized attempt to change the government or leader of a country, usually through violence, which no, this is not that. And then he concludes that whatever went down here, there were, these, as we said, sporadic pockets of violence. That's not it. He says violence is necessary for rebellion, but it is not sufficient, even accepting the questionable premise that people armed with fireworks, rocks, mangoes, concrete, chairs, or bottles of liquid are armed in a 1903 sense. The court is aware of no evidence in the record of actual firearms. There is little evidence of whether the violent protesters' actions were open or avowed. And he said, basically, they don't appear to be all that organized. And, the fact that everybody showed up in the same place, the protesters were showing up in the same place, that's First Amendment protected activity. The fact that people were doing the legal stuff in an organized fashion does not kind of, by the transitive property, mean that the people who were doing the illegal part were in organized fashion. And by the way, if they weren't carrying guns, it doesn't count, really.
It's such a good point to remind, because, I have been kind of marinating in the media coverage on this, and the rhetoric from the other side has uniformly been violent protests, violent protests, violent protests. And the fact that there's no evidence of people having guns is, a pretty good point to remind us of.
Yeah, right. I mean, it's not like there are no guns in the state of California.
Right. And I want to emphasize this, right? As we are talking about violence, right? Peaceful protest does not lose its protection because some members of that protest become violent. Also, violence is not the same as property damage, right? Virtually all of the claims, that there are, I've seen a couple videos of people throwing rocks. Don't throw rocks, right? But virtually all of their claims of violence are actually claims of property damage, right? Mm-hmm. And those are distinctly two separate things under the law, and neither of them are sufficient to strip people from their right to go out and protest what the government is doing.
Exactly. Okay. The second part of Section 12406, which the government is invoking as justification to summon the National Guard, is a part where it says that the president is unable to execute the laws of the land, which, as the state points out, ICE was still out there, making arrests and collecting up in, seamstresses and landscapers and dudes selling fruit. So what do you mean you weren't able to execute the laws? And the government's answer to that was, well, we could have executed them harder if there weren't protests and the like. And the court really had no time for that argument either.
Yeah. Judge Breyer had a pretty good line in his opinion that said, whether ICE could have arrested more people had there been federal troops on the ground, you've got no evidence for that in the record, but that's not the, even if that were true, even if you had evidence for it, that's not the standard as showing that there is a complete and total breakdown of the law, right? The only time that section of 12406 has ever been invoked was during the postal strike under Richard Nixon in 1971, when none of the letter carriers were delivering the mail, right? That is a complete breakdown of that governmental function. No mail got delivered. Here, lots of people still got arrested by ICE. It is absolutely not that factual predicate.
Right.
Okay, so we've been talking about the factual preconditions, right? Is there insurrection? Is there open rebellion? Have the laws broken down? And Judge Breyer looks at that and says no. But there's an even clearer aspect of 12406 that was violated here, and you have to have both in order for it to be properly invoked. And that is, if those conditions obtain, then, quote, orders for these purposes shall be issued through the governors of the states, right? And here, the orders were not issued through the governor of the state. In fact, they were issued contrary to the expressed wishes of the governor of the state. And the DOJ's position here was essentially this kind of crazy backfilled argument that because Pete Hegseth sent a memo to the adjutant general of the California National Guard, and that said it was coming through the governor, and the adjutant general is empowered to act on behalf of the governor. Ipso fatso, it was through the governor. And by the way, like, the governor is just a conduit anyway, so what does it matter if he knows beforehand? I mean, it's such not the law that I think if this survives at the Supreme Court, it will be on the basis of the second half of 12406. Right, like this just didn't happen. Right, we've used the joke 4 or 5 times already in the show of the of all the things that didn't happen, this didn't happen the most. But like, this didn't happen.
Yeah. So do you want to talk about the relief?
Yeah, sure. So I thought this was really interesting because what Judge Breyer did was actually kind of patch up one of the weaknesses in the initial TRO application that was filed by the state. Right, because the state sought this relief on Tuesday, at which point the California National Guard had already been federalized, right? So they were trying to confine it. And Judge Breyer said, yeah, but you also asked me to declare 12406 invalid. I'm going to do that. So the relief that he's awarded is pretty broad. It says defendants are temporarily enjoined from deploying members of the California National Guard in Los Angeles. Full stop. And that defendants is the Department of Defense here, right? Defendants are directed to return control of the California National Guard to Governor Newsom. Full stop. Then the court stayed its order until noon today, Friday, June 13th, as you're hearing this, ordered the plaintiffs to post a $100 bond, which you know, we've talked about again. The court's trying to knit together ways to survive the Supreme Court. So if the Supreme Court says injunctions without a bond are invalid, this is going to survive that. And there was this moment where, again, I thought the DOJ kind of outmaneuvered the California Attorney General's office a little bit, right? Like the DOJ said, we would request, Your Honor, that if you issue relief, that you not issue a TRO, that you issue a preliminary injunction, because that would then give them the right to lodge an immediate appeal.
Yeah, let me just break in to kind of break that down for our listeners, right? So remember, we've talked about temporary restraining orders are not immediately appealable, except that the government keeps immediately appealing them. But the temporary restraining orders, generally they last for 14 days. They can be extended for another 14 days or something along those lines.
Yes.
And they're kind of to establish like a leave time for the parties to argue about it. Here, the Justice Department said, Your Honor, if you issue relief, we'd prefer you to issue a preliminary injunction rather than a temporary restraining order, because they want to do that because a preliminary injunction is immediately appealable as of right, and so they wouldn't have to kind of pretend that the TRO is actually a PI. And because that would obviate the need for further discovery, right? So that there wouldn't be further briefing and there wouldn't be discovery, because they would just like jump immediately to the Ninth Circuit and thence to the Supreme Court. And the state said, look, we don't care whether it's a TRO or a PI. And it's funny because, Andrew, you and I were listening to that, and at the same time we were like, oh, no, mistake, right? Because you want to kind of drag this out. And there are a couple of reasons that we'll talk about as to why you and I really wanted them to drag this out, other than to kind of create time for discovery. But Judge Breyer did not grant the PI. What he did was he granted a TRO, and he said, come back in like 10 days for the PI hearing. So he kind of gave them the best of all possible worlds. Now, I should say that the government did immediately, within like 10 minutes, notice its appeal to the Ninth Circuit. They're going to try and get this undone by the Supreme Court. This is really a race to the Supreme Court for them. But maybe we're going to talk about, let's talk now about why you and I really wanted this to go on. And it has to do with this third issue of the Posse Comitatus Act, because the state argued that the government was already in violation of the Posse Comitatus Act, which says that the military cannot be involved in civilian law enforcement. Now, the government in its reply brief said, well, Section 12406 is an exception to the Posse Comitatus Act, and it allows the president to use military, militias, state militias, whatever, to enforce civil laws, irrespective of the Posse Comitatus Act. That argument was so crazy, they did not even make it in court today.
Right.
What they said is, we're not violating the Posse Comitatus Act, and the fact that you anticipate that we will, in fact, violate the Posse Comitatus Act is not the basis for injunctive relief. And that's right as a matter of law.
That's the only argument that the Trump administration won on in front of Judge Breyer, right? Like he said, it's not in front of me. I can't grant anticipatory relief. And he said, I mean, giveth with one hand and taketh away with the other, right? He said, I would imagine that if I issue a court order, that parties will follow my court order. So maybe the behavior that you anticipate will happen will not happen. Now, I don't think Judge Breyer thinks that's true. He's seen enough of these immigration cases to know it's not true.
Right. And to be clear, the government has said that it absolutely intends to violate the Posse Comitatus Act. You have all of these military leaders saying, we're going to send our troops out to briefly detain, pending so that law enforcement, civilian law enforcement could come and make an arrest. And, if you are not free to leave, briefly or otherwise, you're under arrest. So that's definitionally civilian law enforcement. And that's one of the reasons the state said, Your Honor, we need you to enjoin this behavior anticipatorily because, the president and Hegseth and all of these other military leaders have said that they're going to use these troops to make arrests, although they don't call them arrests. And so what's one of the interesting things that's happening here is that Judge Breyer said, look, we'll be back in 10 days, and I expect we're going to know by then whether there's a violation of Posse Comitatus or not. And I think that was so smart. That's you talked, Andrew, about the court saving the state from it stupidly saying, go ahead, we'll just issue this PI. Because now you've got this, assuming that the Ninth Circuit isn't going to jump in. Now you've got this brief moment, right, where you're going to see, because this order doesn't deal with the Marines, right? Because remember, we're talking about two separate bodies of military soldiers, right? You're talking about the Marines coming in and you're talking about the state militia, the National Guard, right? And if you see the Marines come in and start performing civilian law enforcement stuff, then Posse Comitatus and the Marines will be subject to Judge Breyer's order. Then they will come within the ambit of Judge Breyer's order, which is why it is so much better that we have this brief window of time, because suppose that the Ninth Circuit does stay Judge Breyer's order, and I don't think that's a crazy thing that could happen. I'm not sure that I wouldn't read it one way or the other that they intend to jump in, but suppose that the Ninth Circuit does stay Judge Breyer's order, and you do have the National Guard and the Marines on ground, or even if they don't stay it, you're still going to have the Marines on the ground. We'll know in 10 days much more clearly what the government intends to do with all of these, members of the active duty military in the state. And so then we'll have a much better idea of how they're going to plead this Posse Comitatus issue. Yeah.
A couple of things here. So first, that preliminary injunction hearing is going to be a week from Friday on June 20th. It's actually 8 days, right? It's even shorter. Second, I kind of want to tease out a little bit on Posse Comitatus here, just to try and make it as clear as possible. Because when Trump issued the 12406 proclamation, he specifically wrote it in such a way as to not run afoul of the Posse Comitatus Act, right? So what he said, the federalized troops and then subsequently the Marines would be doing would be protecting federal agents. That does not violate the Posse Comitatus Act. You can send in federal troops or federalized state militia to protect local law enforcement or federal agents who are doing their jobs. They just can't assist them in doing their jobs. Right now, the kind of conduct that the state of California has been complaining against is, from a legal perspective, again, not talking morally, but from a legal perspective, is kind of in a gray zone. So let me give you a concrete example of that. California has said if ICE goes on a raid and the federalized troops or the Marines ring that block and prevent people from escaping, right, that they're really helping ICE conduct that raid. And they're not wrong, but that's not the same as a member of the military forcibly detaining somebody, as you've said, or making an arrest, right? And I think your point, and I just want to make sure that everyone gets it, because it's really, really good, is that in the next 8 days, they will escalate that, right? That's what those troops are there to do. They're not there to stand around and non-existently protect, ICE agents in full body armor from mangoes, right? They're there to assist in the arrest. They're there to take over the arrest. They're there to cause violence. And that additional time will allow the state of California to build the record it needs to give to Judge Breyer that will then hopefully be bulletproof enough for the Supreme Court. I don't know. But I do know that by structuring it this way, it, number one, allows time for building the record. And number two, the flip side of that, it allows the state of California to make the argument that has sometimes been successful in some of these cases, that by the time this gets to the Supreme Court, right, like sometime in the middle of next week, right, the argument is going to be that there is no urgency for this court to step in and issue any kind of immediate stay, right? Let it run. So we're going to have a PI hearing in 2 days. What do you do? Like, let the trial court do its job. And sometimes that's worked. A lot of times it hasn't. But again, it's putting this order in the best possible shape to survive, going up to a Supreme Court that's been awfully deferential to this president.
Okay, that's going to do it for us today. We're going to end on a happy note and have a lovely weekend, you guys. I hope you get out in the sunshine if you are in the hemisphere where it's doing that right now.
And we're going to be back on Tuesday with a fantastic interview that Liz and I are very excited about.
All right. And we will be back on Monday with written content. Thanks, guys. If you enjoyed the show, please leave us a 5-star review on your platform of choice. And if you want to become a member, you know how to do it because we've said it about 15 times this episode. All right. Peace out, guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.
Shopify's point-of-sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.